Good morning, Judge. I have an off-docket matter.
Okay.
You've asked to be here today. It's, I'll give you a cause number when you're ready.
Give it to me.
2500939.
Come up, Mr. Douglas.
Intro. Right out the gate, we've got a surprise appearance. Notice how quickly the courtroom shifts tone when a new attorney steps in on an off-docket matter. Think of this like a legal plot twist. Unexpected and potentially game-changing. But buckle up. This is just the opening move.
Oh,
And if I can explain a bit to the court.
first things first, though, is I have Mr. White that's been representing him.
Right.
And I guess, did I grant your motion withdrawal or we're having a hearing now? All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly
Are you
resolve the
hiring
case for
on?
today.
I'm hired onto this new felony
Okay.
case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
Okay.
sir.
You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony and injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. It goes with you.
And there it is. The gavel may as well be a guillotine here. Bond revoked. You're on bond for a DWI and now facing a felony for injury to a child? The judge isn't just making an example. This is courtroom triage. And for anyone wondering, yes, a new felony while on bond is a fast pass to jail.
Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct? Mr. White?
You didn't file it.
Aaron,
I thought you
did you file a motion to withdraw?
Yes, I filed it last week.
Yeah, I saw it.
I don't have it. I have it. This one.
You said last week.
Yeah.
It's on Douglas.
Oh, I just see an appointment form from January.
I see the motion to withdraw. Yeah, it's there. Do you see it, Seth? Do you need a cause number?
I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? Okay, all right. Tell me. Does,
I know.
look, there's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a third-degree felony, and it's a serious charge. It's not like it's a
but yeah.
trespass, but it's so.
But you know that these charges can be empty.
But I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months.
Has he been blown in?
Nothing.
Nothing?
Done nothing. He's not tested. He's not had. He's literally done nothing. So,
Okay.
anyways,
State's offered a time served. I talked to Michael about it. I'm like, hey, my plan coming in was to try to get him back on PTI
I think
because
they're like,
the felony is so ridiculous it blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any other alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. I mean, look, far be it from me to, because that's what we would do in every case.
Right.
any case that comes back here, and I mean, obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys, so I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
So just so you know, you're not here alone. Your lawyer is here with you on Zoom.
Shift in focus. Now we're watching the emotional undercurrent build. A. Probationer reappears after violations, and the judge is clearly balancing justice with empathy. Notice the term TR. That's a treatment referral. It's the court's way of saying, I don't want to lock you up, but you've got to give me something to work with.
Ma'am, you were placed on probation in this court in 2022. We've had many, many issues. Our first motion to adjudicate was filed, it appears, in November of 23. You were placed back on probation. It looks like a new motion has been filed in February for a variety of things. A warrant had been issued, and I guess now you're here with us. I just don't know how to go forward.
That's why.
Stop. Don't need you to.
Just listen,
right.
please. Don't say
Just
anything.
understand that, now it's not time to fight the case. The only thing that we're dealing with now is the motion to revoke, the underlying issues. And what I see is that you're still testing positive for illegal drugs. I don't know how to go forward, but I don't want to set you up to failure, as well. So what we do is we have something that's called a TRAS, where I have you evaluated by clinicians to see what is the best way to go forward, because I just don't know. The last thing I want to do is just start pleading people guilty here, left and right, and just end up with, conviction after, no. So the idea is that you leave better than you came. It still hasn't happened. So we need to find out how that's going to happen. So I'd like to please set up for TRAS. Your bond is set now at $10,004. So I have to take you into custody because of the warrant. So I will try to get it done as quick as possible. We could probably have a TRAS done. Do you think maybe tomorrow?
She'll probably still be in processing tomorrow, but by the end of the week.
Okay, we will try to have it done by the end of the week. They will give us guidance on how to move forward, because I just don't know at this point. The only thing I'm going to tell you is please be honest, because if I get it and it says that there's no issues and it's rainbows and gumdrops, and I know it's not true, and we're going to do it right over again. Okay? Okay, so she goes with you. Okay, thank you, Mr. Bernie.
And Your Honor,
Yeah,
if possible, can we try to get the TRAS done by Thursday so she could be in court Friday? Because I'm out.
I will. I'm going to try. So the problem is, though, is that what takes a lot of the time, Brock, is the processing. Because we're taking her in now, it's nearly 11 o'clock. They'll probably still be processing her early into tomorrow. If she's still in processing, they can't get it done. Maybe in the afternoon, tomorrow afternoon, they can get it done. I would say probably the latest, today's what, Tuesday? Maybe the latest is Thursday to try to get it done. And then we can try to get the results by Friday.
Okay.
And that's
Put it on the
if
docket
everything
for Friday?
goes- Yeah,
Can we
hopefully.
Can we put it on the docket for this Friday, Your Honor? Like I said, I'm out all next week. I don't want her to.
So because she's in processing, because she'll be processing now, she will auto-populate on tomorrow's docket.
Okay.
And we can put her on for the Friday. So I
Sounds
can't
great.
really put her on for Friday yet because she'll auto-populate for tomorrow. But tomorrow, then I will put her on for Friday.
No problem. And can you consider reducing the bond somewhat, Your Honor?
No, this is our third case within the last two years. We've had multiple MAJs. I mean, she's doing what she wants to do, and that's it.
I understand, Your Honor.
Thanks, Brock.
No problem. I will see you Friday.
Okay, I'll reach
Have
out
a
to
good
you tomorrow because she'll pop on tomorrow's docket, so I'll reach out to you tomorrow regardless.
Yes, Your Honor. Thank you.
Okay, thanks, bud. Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now, and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard, and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver, and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle, and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted, and 4 bags were located under the driver's seat, 0.154 ounces.
A tiny bag of weed, but a giant legal problem. Let's be real. Possession isn't just about the substance. It's about context. Here, he's on felony probation for aggravated assault. The court expects halo behavior, and instead it's the scent of marijuana that leads to more handcuffs. Pro tip, don't violate probation with the windows down.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm gonna find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm gonna appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or 2 to figure out what happens, okay? All right, man, good luck.
If you'd be willing to
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not gonna let you go, you know? I mean, you know, marijuana, no, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm gonna revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you
Goes
set
with you.
on that, Judge?
$5,001.
5,001. And Judge, I have 2 more.
Okay.
I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, this is the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
No. What's the last name again?
Flores, Judge?
Thank you. Yeah, 5,002.
5,000.
Yeah. Good morning, Mr. Wolf.
Good morning, sir.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Reville Street regarding a minor crash. Officer 1 made contact with Officer 2, who on-viewed a 2 motor vehicle accident. Officer 2 observed the defendant operating a silver Ford minivan and crashed with a black Hyundai Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes and sluggish speech and poor balance. SFSTs were administered. 6 out of 6 clues on the HGN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one-leg stand. The defendant was placed under arrest and read the DIC, and he consented to provide a blood specimen.
It's not back.
No.
Prior DWI, one from with us or any more?
It looks like there is a pending DWI from Galveston County from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want to know if you have an open DWI. I have found that there's probable cause to go forward with your DWI second in here. You also have another DWI in another county. Stop.
Okay, that was driver without license.
Stop.
Yes, sir.
I don't want you to say anything. I will appoint your lawyer today, but it's unacceptable that you continue to pick up cases here, there, everywhere. Unacceptable. And I don't think that a PR bond is the right thing to do. I'm now going to revoke the PR bond, and he goes with you. You're a danger to our community.
Boom. That's the sound of patience snapping. The judge just revoked a personal recognizance bond, the legal equivalent of, you had one job. Why the harsh stance? It's the second DWI, plus an open one in another county. To the court, that's not coincidence. That's a pattern. And dangerous. Patterns get shut down fast.
It's unacceptable.
Just driver.
Stop. I will appoint your lawyer. I don't want you to say anything now. I would like to talk to a lawyer. Can you appoint him someone, please? You are not to drive at all. I don't care what you're going, what you need to do. Do not drive. The only thing I'm asking you to do is please don't kill someone on our roads. That's all I'm asking you to do, man. Every single day, we have an intox man, an assault that happens because of this.
Fantastic.
Stop. There is probable cause to go forward. We have trials to determine that, but I have found that there's sufficient to go forward. You've got multiple cases open in another county.
Let's pause and absorb what's stacking up. 2 DWIs, 2 different counties, overlapping timelines. This isn't just legal whack-a-mole, it's a coordination nightmare. Now imagine being the defense lawyer walking into that storm. This is where smart lawyering and solid case strategy become survival tools.
Goes with you. I will appoint your lawyer. Tell your side to the lawyer, and then we can talk after. You're saying it is an open DWI in Galveston.
Did speak to the clerk, they said it was an open DWI, yes. And I double checked, and I was going to speak to the prosecutor because they were.
I get it. No, I get it. But if you've been able to verify with the clerk over there that he has an open DWI second there, and now a DWI second over here, no, 20,000. 20,000.